If it may please the court, my name is Alex Bergener. I represent defendant appellee Daniel Biederbeck. And as an initial matter, it is our position that the trial court did not err in its decision not to award punitive damages. And as you have discussed with appellant's counsel, we have two other objections to punitive damages even being awardable under the facts presented at trial and the decision of Judge Cohen in this matter. The first one is evil mind. It is our position that evil mind is a necessary component of any punitive damage award, that the fact finder would need to make a determination of that. For that, we look to Rawlings v. Apodaca, which is one of the cases appellant looks to for his entitlement argument. And Rawlings, we just take a little bit of the language out for some flavor. They say, we do not believe the concept of punitive damages should be stretched. They go on to say, thus, to obtain punitive damages, plaintiffs must prove defendant's evil hand was guided by an evil mind.
Go ahead. Go ahead.
Well, counsel, can't we get to the evil mind from the fact that there was intent to injure and actual injury caused? Why do we not get to evil mind from the establishment of intent to injure and actual injury by a preponderance of the evidence?
And that's the other portion that we disagree with, as you've identified as the standard. It's our position that we don't get to evil mind from intentional torts for primarily the same reasoning outlined in Rawlings, which considered whether or not bad faith, which is an intentional tort, automatically comes with punitive damages. And the Supreme Court in that case decided that was not so. Now, they would have us impute the evil mind based on the type of torts. Again, that's been analyzed and dismissed in Rawlings. Here we do have the intent to do harm portion in these torts, but even Linthicum v. Nationwide Insurance held, before a jury may award punitive damages, there must be evidence of an evil mind and aggravated and outrageous conduct. So it's our position that based on the evidence presented at trial, there was evidence of aggravated and outrageous conduct, but it's our position that no evil mind evidence was put on. And therefore, without the evil mind being found, that you cannot award punitive damages.
How do you commit an assault without having an evil mind? Explain that to me, counsel.
Okay, it's my position that if we modify these circumstances slightly, this is an event in which a then husband and wife had a slight altercation, or had an altercation, a physical altercation at their home. It's our position, it's Mr. Biederbeck's position, that was not, he didn't have an evil mind at all. He was just acting on impulse. And we would say evil mind would, for example, be something like, had he, with the intent to do harm to his wife, lulled her to some secret location and then accosted her, or put some forethought into the activity, that would be.
So evil mind requires premeditation?
It's our position that the evil mind needs to be determined by the trier of fact. So in each case that would be different, and it's our position in this case the judge did not, in his opinion, come to the conclusion that there was evil mind. So that's our position on the evil mind factor, and you may or may not agree with us. But we have our additional obstacle that we feel that the appellant did not meet is the burden of proof. And you've all sort of discussed that. It would be our position that if you are accepting this imputed evil mind that we believe has been examined and discarded in Rawlings, if you are persuaded by that argument, though, our position is that the underlying torts themselves would have to have been proven with clear and convincing evidence.
And just to keep us straight with our discussion, the court below never found the element of that the element of the evil mind had been established.
Correct. And it's our position, therefore, they can do the punitive damages. But even if we're going with the imputed evil mind, our position is those underlying torts would have to be proven with clear and convincing evidence. And for this authority, we look to page 332 of Linthicum v. Nationwide, where it says, while a plaintiff may collect compensatory damages upon proof by a preponderance of evidence of his injuries due to the tort of another, we conclude that recovery of punitive damages should only be awarded upon clear and convincing evidence. And as identified by the panel, the present case, the court on page 1 in his ruling said each claim must be proven by preponderance of the evidence, and after doing a credibility analysis of both parties, came to the conclusion that discerning the truth is a fairly monumental task, and he just decided whether or not it was proven by preponderance. So, in reply brief on page 12, the appellant states, the clear and convincing standard applies in situations where there is some debate on the existence of an evil mind sufficient to support punitive damages. And we agree with that. We say that this is a situation in which we dispute there being evil mind. Therefore, Linthicum already tells us the clear and convincing standard applies, but even the appellant agrees. So for Judge Cohen's trial ruling, although we didn't agree with all of it, it was well thought out, well written, and deliberate. And so for the reasons I've stated, we ask this court to affirm the lower court ruling. And I'm happy to answer any questions.